Hi, I'm Greg Dell with attorneys Dell and Schaefer, here with attorney Alex Palamara, and we're going to discuss about lawsuits against Dearborn National or another subsidiary, Fort Dearborn, with regard to long-term disability insurance claims. Now, I know that, Alex, we filed lawsuits against this company in the past, and what's interesting about these particular claims is that they have ERISA type policies, which means employer provided policies, but some of them may be ERISA exempt because we know that Dearborn National writes the group disability policy for the entire University of Texas system, and since that's considered a public institution, it's likely exempt from ERISA, which allows you to bring a public type lawsuit not governed by ERISA. So we'll talk about lawsuits against them from the ERISA standpoint, and then we'll discuss what it's like to be ERISA exempt and the advantages of that. So let's first go on to what a person needs to expect in their Dearborn National ERISA governed lawsuit.
Well, as everybody knows, the Employee Retirement Income Security Act are laws that are not favorable to the insured. So ERISA laws can be pretty difficult because not only do you have to prove to a judge that you're disabled, you have to also prove to the judge that the decision by the insurance company is arbitrary and capricious in most scenarios. And most Fort Dearborn or Dearborn National policies that I've looked at, there is discretionary clauses in them, which makes it an arbitrary and capricious standard to prove to the judge that somebody is disabled. It makes it a little bit tougher to win.
And what does that mean, the arbitrary and capricious standard?
So in most lawsuits, you have to prove, if you prove that you're disabled, you win your lawsuit. So like you were talking earlier about a non-ERISA claim, under most of those policies, if you prove that you're disabled to a judge or to a jury, you win your lawsuit. In this scenario where there's a discretionary clause, in order to prevail, you have to prove to the judge that you are disabled, number one, and then if you prove that, then you get to the second step, which is proving to the judge that the decision by the insurance company is arbitrary and capricious. Essentially, that the decision they made had no reasoning behind it. It was without reason. Pretty difficult to prove something is arbitrary and capricious, and that's why the insurance companies win something like 85% of the lawsuits where a judge renders a decision under an ERISA-governed policy.
Okay. And what is the typical definition that a claimant's dealing with in a claim denial when they have to file a lawsuit against Dearborn?
It's a pretty typical disability insurance policy where the definition of disability changes after a certain time period. For the first 2 years, typically the person has to be unable to perform the material and substantial duties of their own occupation. Then after 2 years, it gets a little bit more difficult, and they have to prove that they can't do any occupation. Any occupation typically means a sedentary job. They're supposed to take into account your training, education, and experience, and your previous earnings. Sometimes they just say you can do a sedentary job, you can now get back to work, we don't find you disabled. That's typically how the insurance company denies those claims.
And in terms of your experience in handling these claims against Dearborn National, how long do these lawsuits usually take?
From the time of a final denial letter, so you already filed your appeal and the insurance company's denied it, and now the only avenue left is to file a lawsuit. I mean, Fort Dearborn / Dearborn National is not one of the major players, I would say, in these type of disability insurance group policies. Definitely in Texas, they're one of the major players, but here, anywhere else across the country, not one of the major players. From the time you file a lawsuit, it can take anywhere from a matter of months. If you're looking for a negotiated resolution, a settlement can take, we've filed lawsuits and settled within 30 days of filing a lawsuit. It can take up to the day of trial, where the judge, you can file the motion for summary judgment and you can settle, 18 months in before a judge renders a decision. The night before the judge renders a decision, you come to a negotiated resolution. Or to get a ruling from a judge can take 18 months, sometimes 24 months. Anywhere from, I would say if you file a lawsuit, you probably expect an answer within, or some sort of resolution, anywhere between 3 months and 18 months on the average.
And in terms of litigating, what should a person expect as a potential outcome? I know you said a lot of these cases are won by the insurance company, and that's because of the standard of review that may be out there, but we have a very good success rate in these cases. But regardless of our success in terms of winning these cases, and I guess winning is a subjective term because the idea is to get benefits paid to claimants at the end of the day. So what's the normal type way in which these cases end up being resolved once a lawsuit's filed?
Well, 99% of cases that are filed, whether it's a disability insurance claim, whether it's a car accident, slip and fall, any type of lawsuit, even the criminal case, 99% of the cases end up in a settlement. In a criminal case, a settlement's a plea bargain. In a disability insurance claim or a personal injury claim, the two sides come to a negotiated resolution, a settlement where it says, we'll accept this amount of money to make our claim go away, to basically for us to give up our rights to this lawsuit or this ongoing lawsuit, we'll accept this amount of money. 99% of the cases end up in a settlement just because if they didn't, our legal system would collapse because we don't have enough judges out there to be able to render a decision on every single lawsuit. They kind of depend on settlements, which is why most federal judges require that you go to mediation once you file a lawsuit, which is basically where the two sides get together, see if they can hash out a resolution of this. The other reason why there's settlements is because letting a judge decide, there's so much uncertainty. You don't know. A judge can go either way. So settlement will give you certainty where there currently is no certainty. So sometimes a settlement is in your best interest. We always take a look at all the facts of the case. We have to weigh the potential outcomes, what the risk is. We have to figure out what the risk is of you going forward or what's in your best interest. To negotiate a settlement and get to a certain amount of money, if there's a certain amount of money there, then sometimes it's your best interest to accept a settlement. The old adage is a bird in the hand is worth more than two in the bush because you know what you're getting with a settlement. You don't know what a federal judge is going to do.
So we mentioned earlier that you have the group policies and that's going to be in the hands of a federal judge. And now let's jump gears and talk about the ERISA exempt claim, which is going to be filed as a breach of contract type claim not governed by ERISA. What are the significant advantages for that claimant versus the ERISA claimant?
Well, first and foremost, ERISA stinks also because there's no jury trials. You have one person rendering a decision on your claim. It's a federal judge. No matter if they're appointed by a conservative or a liberal president, most of these people are pretty conservative people. To be a federal judge, typically you can't have any skeletons in your closet. So they're pretty conservative people. They might not be able to see, you as a claimant, as a person, as an individual. You kind of want to have a jury trial in this scenario, just a jury of your peers who can, see themselves in your shoes and taking on a big multi-billion-dollar corporation who's basically giving you, saying no, 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 and overlooking all your medical documentation. You can't understand why. So a jury trial is more favorable in this scenario, but the laws governing these claims are way more favorable. Typically, they're state laws. You don't have this arbitrary and capricious standard that ERISA does. I don't want to say they're easier to win, but they're somewhat easier to win because the standard that you have to prove is a little bit easier to prove than an arbitrary and capricious standard. You have to prove that you're disabled. If you prove that you're disabled, you win, or you should win.
Now, I want claimants who are watching this video who are saying, okay, I'm a University of Texas employee or a government employee and I'm not governed by ERISA. Completely different ballgame in terms of bringing the lawsuit. On the ERISA side, you're never going to have to do anything. They're not even going to take your deposition. There's going to be no interrogatories, no request for production. You're basically literally going to have to do nothing except continue your medical treatment, which you're going to do anyhow. On the other side, if we end up filing a private lawsuit, you're going to be involved in the full-blown litigation, which means having to do interrogatories, which means answer questions, having to produce tons of different kinds of information, potentially having to give a deposition. Your doctors are going to be deposed, which they can't be in ERISA. They're going to possibly depose coworkers, your employer. In ERISA, that's not going to happen. So some people like the privacy and protection of ERISA and the fact that there's no discovery, but in the non-ERISA, you're really getting your full day in court. You as a claimant have the opportunity to come in and testify and explain why you can't work. Your doctors get to come in and testify as to why you can't work. So 9 out of 10 times, I would take the private non-ERISA claim and be able to have my full day in court and explain my story and have my doctors come in with the evidence rather than just rely on the papers, which is what the judge has to do, and rely on the decision of a judge who's never met you, doesn't know you, and basically is just limited to what's called the record. Right. So huge differences. Plus with the ERISA, non-ERISA, you have potential bad faith claim for damages that you can bring. You can possibly get punitive damages if the company acts extremely reckless or shocks the conscience in their claim handling. Very rare, but it's an opportunity of something that could be out there, not something that you should bank on. But you just have so many more rights, and also those rights create more value. And when you talked about, you still have the similar resolutions, whether it's a lump sum or you go to verdict and get your past due benefits, but you really are better off if you're ERISA exempt. But if you're not, there's far more ERISA governed policies than there are non-ERISA policies. Right. So that seems to be the norm. So with regard to your Dearborn National or Fort Dearborn claim for litigation, once your claim's been denied or you're feeling that your appeal is going to be denied, really whatever stage you're at, feel free to give Alex or myself a call. We help claimants all over the country. We're going to provide you with an initial free phone consultation to discuss your claim, which should bring you some comfort right away to know that you're going to get a lawyer on the phone and we're going to tell you immediately whether or not we think that we can help you. If you have a Dearborn National claim and you're just in a situation where you happen to stumble upon our video, we welcome you to our videos and our YouTube channel. We encourage you to subscribe to our YouTube channel because we're regularly offering what we believe are helpful videos in which we talk about how to handle disability claims, how to do an appeal, what to expect in an application, all different kinds of videos on medical conditions, and we'd like to share these future videos with you and for you to get notifications of those. So feel free to give us a call and we welcome the opportunity to work with you in the future.